untreated drug addicts in the United States report that the reasons they did not receive treatment include either the unaffordability of drug treatment or the concern they will face workplace repercussions for enrolling in treatment or rehab. The Americans with Disabilities Act and the West Virginia Human Rights Act protect employment rights of drug addicts by providing that no covered employers may discriminate against drug-addicted individuals because of that individual's drug addiction in regard to job application procedures, the hiring, advancement, or discharge of employees, employee compensation, job training, and other terms, conditions, and privileges of employment. This panel will discuss how these civil rights laws can be used to improve the prospects for successful rehabilitation and gainful employment for drug and alcohol addicts. Now I'll turn it over to Professor Lofaso.
Hi everyone. We are going to start with a very short, about 12-minute videotape that was done by Pat McGinley. He's a professor here, and it's all about the opioid crisis. You probably know that Eric Ayre of the West Virginia Gazette won the Pulitzer Prize for his incredible work about opioids, and Pat McGinley actually worked with him and his wife Suzanne. So we asked Pat if he would, both of them did work with us, but we asked Pat to do this. So we're going to start that, and that will give us some background, and then we'll proceed.
Good afternoon. It's a pleasure for me to join you remotely from Knoxville, Tennessee, the University of Tennessee, where I'm giving a talk about the opioid epidemic, which is also the focus of this panel. And it's my privilege to be able to talk to you about the opioid panel with this distinguished group who are focusing on part of the opioid epidemic, what happens to those who are addicted, and how do we get them back in the workforce and get them back on track and save their lives. The reason I'm here is because of my experience in litigation, seeking information about the opioid epidemic here in West Virginia. I was privileged to work with WVU law professor Suzanne Weiss and Boone County attorney Tim Conaway, who's also a WVU law graduate, on behalf of the Charleston Gazette Mail, working with its investigative reporter Eric Ayre as he undertook to investigate the issues revolving around opioid problems here in the state. And the story goes back to, in part, 2012, when former West Virginia Attorney General Darrell McGraw filed what became known as the pill mill lawsuits against major national drug distributors who are involved in distributing opioids here in West Virginia. And the allegation was that those companies were literally dumping massive amounts of opioids in the state, and that distribution had contributed to a terrible drug epidemic here in the state. And ultimately, in litigation, we had two goals. One was to seek the unsealing of court records in the pill mill cases that we believed would disclose the scope of opioid distribution by major drug companies in West Virginia, and also to force the current Attorney General, Patrick Morrisey, to disclose records that he had received from the Federal Drug Enforcement Administration that would inform the public regarding the drug distribution of opioids in West Virginia. And we were fortunate to to be successful, and the disclosure of those records were shocking. That's the only way I could say it. We thought we knew something about the drug, the opioid epidemic, but when the court unsealed the documents in the pill mill cases, and a few months later, Attorney General, under pressure, disclosed to Eric Ayre and the Gazette-Mail DEA information, it was truly stunning. And a little bit of background to set the stage for the discussion of the panel that will follow. West Virginia has the highest drug overdose fatalities in the nation. The American Enterprise Institute issued a report saying that 12% of West Virginia's gross domestic product, twice that of any other state, was being shouldered by West Virginians, and that as a result of the opioid epidemic. They also calculated the cost to West Virginia being $8.8 billion. A lesser calculation by West Virginia University economists attributed the amount to be $1 billion. 84% of the children in West Virginia who are in foster care are there because of drug problems in their families. Their experiences in those households raise the risk of them becoming drug abusers. What we found as a result of litigation and Eric Ayre's investigation was that opioid painkillers were being distributed in places like Kermit, West Virginia, that had a population of 392. But there, out-of-state drug companies shipped nearly 9 million doses of highly addictive, potentially lethal oxycodone pills over 2 years to a single pharmacy. Kermit is in Mingo County. Mingo County has the 4th highest prescription opioid death rate of any county in the United States. The trail of opioid abuse weaves through Wyoming County, where shipments of OxyContin doubled. The county overdose rate there leads the nation. One mom and pop drive-through pharmacy in Oceana received 600 times as many oxycodone pills as the Rite Aid drugstore just 8 blocks away. In 6 years, drug wholesalers showered the state with 780 million hydrocodone and oxycodone pills. Well, more than 1,700 West Virginians fatally overdosed on those 2 painkillers, according to the investigation of the Charleston Gazette-Mail. This huge shipments of prescription opioids to West Virginia amounted to 433 pills for every man, woman, and child in West Virginia. Records disclosed by the Attorney General showed that pills sold to every pharmacy in the state and drug companies, shipments to all 55 counties in West Virginia. Wholesalers, the drug wholesalers, fought to keep the sales numbers secret. But when they were disclosed, that disclosure, through the work of the Gazette-Mail and Eric Ayre, awakened the country to the enormous scope of the opioid epidemic. To put this in perspective, CEOs of the 3 largest drug distributors, McKesson, Cardinal Health, and AmerisourceBergen, They receive tens of millions of dollars in salaries and bonuses. McKesson has grown to the 9th largest corporation in the United States. In 2012, its CEO was the nation's highest paid executive, according to Forbes magazine. Cardinal Health shipped hydrocodone to Logan County. Its shipments increased sixfold over 3 years. AmerisourceBergen's oxycodone sales to Greenbrier County soared from 292,000 to 1.2 million a year. McKesson saturated Mingo County with more hydrocodone pills in 1 year, 3.3 million, than it supplied over the 9 previous years combined. Year after year, drug companies ship pain pills in increasingly stronger formulations, according to DEA data. Addicts crave stronger pills over time to maintain their addiction, and the drug companies satisfy that. At no time were any of these drug company executives or the companies themselves held responsible. And the fact of the matter is that there's plenty of responsibility to go around for this epidemic. The law enforcement that failed to take action, doctors who wrote scripts to people who were basically taking the prescriptions and selling them on the streets. The drive-through pharmacies that sold nothing but opioids, and the drug manufacturers and the drug distributors. The latter profits were in the billions. Fortunately, now that the word's out and we're here, I'm in Tennessee and you're in West Virginia talking about the opioid epidemic. The results of the Gazette Mail reporting is attention being brought to the issues of the epidemic. The president has declared a health emergency, a national health emergency. Scores of lawsuits have been filed against drug manufacturers and drug distributors by states, cities, and counties. Members of Congress, committees of Congress are investigating to determine the cause of the epidemic and what can be done about it. Eric Ayre and the Gazette were awarded the Pulitzer Prize for their, in the Pulitzer Committee's words, courageous reporting. And so that's the backdrop for the discussion of this panel today. There's so much to do. The addiction is such a difficult problem to deal with. It can't be done on a shoestring. There are multiple approaches that are being considered across the country to try to wean people from this addiction. And one of those approaches is a topic of the discussion for this panel. It's been a pleasure to join you remotely, and I hope that the panel goes well, and the symposium is something that I think we need in West Virginia.
Our panel is called Working for Recovery, How Civil Rights Laws Can Facilitate Successful Rehabilitation for Alcoholics and Drug Addicts. I'm Ann Lofaso. I'm the Arthur B. Hodges Professor of Law here. I teach labor and employment law. Before Sam and I present our paper, we're going to have each of the speakers present themselves, introduce themselves, and how they're an expert on this topic. My expertise comes primarily in my the workplace. I am a labor and employment lawyer, and I have litigated disability suits. When the call for papers came, Sam approached me about this, and we both thought this was an incredibly important problem because, as we just heard Dr. Deskins talk about at lunch, that 2 of the 3 top reasons why we are having problems with jobs and job growth in West Virginia are education, or less than average educational system, and also opioids, the drug problem. And until we fix this problem, and by the way, fixing it does take money, so we're gonna have to figure out where that money's gonna come from, then we're just going to continue to be in a recession. So we have to accept that reality that, yes, the answer just can't be, well, we have no money, because we have to fix this or we're just gonna continue to have no money. So this is a very narrow topic that we're just doing one little thing, and I will now turn it over to each of them. How we're gonna do it is each speaker is just going to give a very brief introduction of themselves, then Sam and I will present the paper, and then they're going to respond to the paper. Then we would like you to give your comments, criticisms, whatever you want, because we want to make the paper even better by having an interactive conversation. Sam, would you like to introduce yourself?
Well, sure, I will introduce myself by way of introducing the rest of the panel. So, briefly, I'm Sam Petsonk, and I'm an attorney coordinating the workers' rights practice at Mountain State Justice, which is a nonprofit legal services organization with offices in Beckley, Charleston, Morgantown, and elsewhere around the state. I'm based out of our Beckley office. So we have Linda Carter Batiste from the Job Accommodation Network, Ashley Bledsoe, and Linda is an attorney and a consultant with the Job Accommodation Network. Ashley Bledsoe is a psychologist with the Southwestern Day Report Center in Logan, West Virginia, and Bob Edmundson is a clinical social worker and associate professor at WVU. We'll hear from them about their experience with the impairments, treatment needs, and general adversity faced by addicts in their experience, and we'll proceed with presenting our paper and engaging in conversation.
Want me to start?
If you would.
Hi, everybody.
I'll keep a little bit of a time check here, so look
All
over
right.
and I'll.
Just give me the red light when
Okay.
you want me to stop. My first question for you guys is, how many of you are familiar with the Job Accommodation Network? Have you ever heard of it? Oh, this makes me very happy. I didn't think anybody would raise their hand. We call ourselves the best kept secret in West Virginia because we are a federally funded resource for the entire country and its territories. But we are located at WVU, and when someone calls me from Morgantown or anywhere in the state, they're always shocked that we're here. We get more calls from California and Texas than we do West Virginia, so we're always happy to share information with people from West Virginia. Our mission, our purpose for being where we are is to provide information on workplace accommodations in the hopes that if we provide this information, people with disabilities are more likely to get the accommodations they need and get the employment that they want. And we basically work out of our office here in Morgantown via telephone. You can email us, you can chat with us, and anyone can use us. It tends to be mostly employers and individuals with disabilities, but anybody can use our service. And just to give you an idea, we average about 50,000 calls a year now, calls, emails, chats. So been around since 1983 when the phone used to ring every now and then, and now we have 13 lines and they're lit up all the time and we're crazy busy, so I'm very happy to be here not answering the phone right now. One of the things that I've been there since 1992, right before the ADA went into effect, the Americans with Disabilities Act, and that's what really changed our services and made it take off like that. Things aren't perfect for people with disabilities, as you'll hear, but there has been improvement. There's been some changing attitudes. We get a lot of calls, a lot of accommodations being made. I've always specialized in, one of my specialty areas has been substance abuse, and honestly, unfortunately, that's an area that's kind of lagging in making any progress. The employers that call us a lot of times still really look at addiction as a behavioral issue rather than a medical condition. They feel like, hey, you did this to yourself. It's your problem, why should we have to deal with it? Employers tend to be a little more helpful for employees with addictions who volunteer their condition and ask for help, maybe ask for leave, as opposed to someone that's caught up in a drug test, or maybe a coworker narcs on them or something, but somehow the employer finds out in another way, and that's usually they're terminated, and that's the end of the game. The employees that call us, the employees with addictions, tend to be looking for their rights on the Americans with Disabilities Act. They want to disclose, they want to get help, but they're afraid to do that because of the stigma, and also because they're afraid they're going to lose their jobs, they're going to lose their health care, and then they're not going to be able to get the treatment that they want. They also call us sometimes when they need accommodations to maintain sobriety, and again, they're afraid of disclosing because they don't necessarily want their employer to know that. So that's kind of what we see in our calls. The law doesn't protect people with addictions as well as it does people with other conditions. There's some loopholes for current use. And when someone's currently using, that's the time when really they need accommodations the most. They need the time for treatment. They may need some accommodations to keep working. And that's the time when they're most likely to lose their coverage. So we see this conflict for people with addictions in our work, and unfortunately it's continuing to be a big problem, and I think a big gap in the way the law works. Am I on time?
Oh, yes, very much so. Go ahead.
Hi, my name is Ashley Bledsoe, and I work for the Southwestern Regional Day Report Center. We provide treatment for those with a substance use disorder that are in the court system. So typically my clients have a felony offense, and they are seeking care as possibly pre-trial or part of their sentencing or so on and so forth. We also do drug screening as well. Our day report centers are in Lincoln County, Boone County, Mingo County, and Logan County. So we cover multiple circuits as well. And one of the things that I'm hoping to speak most on is the fact that my clients do not typically have a current job. That's why, A, probation sends them to seek treatment because they're not working. If you go through the court systems and you have a job, whether you have a substance use disorder or not, they want you to maintain that employment. So they go ahead and say, okay, part of your probation, you're still going to stay employed. You're not going to be referred for day report substance abuse treatment services. But typically speaking, when you get to the point where you have a felony offense, you probably haven't had a job in the last 5 years, give or take. Just because of the type of things that you would have been involved in during that time. You would have been more focused on your substance use rather than attaining other life goals such as college, employment, family issues, so on and so forth. And so once our clients go through the legal system, now they have a felony on their record, and we're saying let's get treatment, let's make change, but they are very limited on what they can access for employment or for education or for state-funded services that are intended to help those when they are down get back on their feet. So that's about it. Go ahead, I'm quick.
Okay, Robert or Bob Edmundson. I'm an associate professor at behavioral medicine psychiatry at WVU. I am probably the clinician of the group, or at least a long-term clinician. I've been treating drug addicts and alcoholics for 25 years, mostly at this place. I've treated thousands. I continue to. I had a group last night. That's my last activity of the week. So I've been around all of this for so long. And, part of what I'm doing is sitting here reacting to everything because I haven't had an opportunity much to think about this in the context of not only this paper, but this whole panel in general. So I'm kind of just reacting because as I read up again and noticed the AD, I'm thinking, has that really been around? I almost forgot about it because, and of course what Linda said pretty much answered that for me because people are afraid to use it or somehow people aren't connecting the dots. I mean, I have felt like some of us have been kind of not lacking in some of the knowledge about how to get people connected. I just feel like there's a need for so many services to accommodate individuals. And I appreciate the stigma reference. That's one of obviously my first comments about dealing with addiction, both for, the idea of employees seeking help, or in some cases, the employers accommodating help. Especially when you're talking about addictions now, I guess, limited this discussion to alcohol and drug addiction, because I treat alcoholics too. But between the two, I think drug addicts are definitely judged more severely than alcoholics. And so, but I have, as I said, witnessed so much over the years of persons who either are employed, were employed, are either laid off or unable to work while they're in treatment. All of these categories that fit a lot in what you said also, which is, people come, and even if they were fairly well-to-do, even in their occupation and whatever, in the course of treatment, they lose a lot of that, or unless they have a bunch accumulated, they don't have a lot of resources. So the same needs that the, near indigent person might have often is similar to what somebody who maybe was well off before because of what has been taken away by addiction and what is the inability to work. So, by the way, when I was reacting to that number of pills used that was on the tape, and I just thought of this, I'm sort of thinking of all the years we've been trying to deal with people coming at us and not recognizing just how powerful the push was on the other end. Just how, it was like, I felt like, I have a humorous statement I always make to my son-in-law when I feel pretty rough, if I'm tired out from working too hard one day. I always say I feel like I was in a gang fight and my gang didn't show. And honestly, I sort of feel very similar up to this point. So I hope that not only will this symposium, but others and the sensitizing that's occurred statewide will indeed pay off. But we've got a lot of work to do, and I've got a lot to say about it in terms of just how much needs to be done. Because if you fall short, it's not going to work in most cases. So I probably ought to quit now or what?
Well, can I, maybe just to flesh out what you said, and I'm going to, actually for a couple of you.
9 minutes.
Yeah, you're under your time. As
You all went under your time, which is impressive.
Well, you made a comment about people on the upper end of this income spectrum who still face challenges.
Yes.
Can you just elaborate? Are you talking about challenges when they've been on inpatient treatment without pay from work and they've been without income?
Sometimes. I deal with a certain portion of my work is with professional population, and some of these individuals, because of the nature of their issues, lost the ability to earn income during a period of time, and yet are also sort of forced, if it be, into, in some cases, long-term treatment, which, by the way, is an incredible model. I could speak highly of it in terms of how more people need this kind of thing. But on the other end of it, a lot of times, again, unless people have a lot of resources, they feel that financial crunch too in their lives because they don't have an income. So, and again, depending on how deeply embedded they were in the addiction, they may have fallen down on the ability to generate income for some time before they actually were teased out too. So, but yes.
When you say they need long-term treatment, are you referring to? Can you describe the needs for long-term treatment more particularly? That is, are you referring to inpatient treatment over the long term or outpatient treatment over the long term? Do you encounter long-term needs for both in and outpatient treatment, or does one of those types of treatment tend to be shorter in duration when you're talking about these longer-term treatment needs?
I think we almost have to first start with what is available, because many of those variables represent what is now available, either an outpatient program, in some cases inpatient rehab. What we know to be true when we talk about the addictive nature and things being an addiction, people have to realize that we are dealing with a chronic illness. It's a chronic illness. This is cancer. This isn't something that you treat and it goes away. And so from an employer standing, I see the real challenge between employers recognizing that and accommodating people, and yet the strong need for that to happen, because if it doesn't, often the chances of somebody sustaining sobriety or recovery are diminished. And so that's one major variable with all of that. And the idea of longer term, one of the comments I wrote is that, when it comes, if you were an addict or an alcoholic, you come to realize that more is not better. But for treatment, more is better. The more you can get in a structured environment with accountability, that's the buzzword. if not the key word when it comes to addiction treatment, accountability. And fortunately, I've come across some models in recent times that really demonstrate that even more so by the amount of accountability that is contained in those. And so it's a long-term process. So.
Thank you, that's helpful,
Yeah.
I think, describing
Okay.
the needs for treatment, perhaps over the long term, even during periods when a person is not actively or currently engaged in the illegal use of drugs.
Absolutely.
And Ms. Batiste, you had mentioned that the period when an employee or an individual is currently engaged in the illegal use of drugs is, I believe you've used the phrase, that among the neediest times.
Right.
Can you say more about the types of needs that you encounter, or that you hear about during that time when someone is what are the treatment needs that you find that people encounter while they're currently engaged in illegal drug use?
I think it depends. We hear two things. When someone's currently using and they get caught using, the big issue there, a lot of times it's the family that calls us. The person may not be ready to admit, I have a problem, I need treatment, maybe in denial. I think for that individual, I think they need to hear what's going to happen here if you don't own this and you don't look for a way to improve your performance and your conduct and deal with this medical issue that you have. We also see people who have made that determination that I have a problem, I need help, I need to take, typically it's going to be leave time to go get treatment. Sometimes it's outpatient treatment and they just need a flexible schedule or a reduced schedule. A lot of times they need to reduce their stress that they're under at work, and the employer may be able to modify some things so that they can continue working, especially to maintain their insurance. So I think it depends on where the person is, what their limitations are, and what they're going to need. But typically, either way, the person is initially going to need treatment, time off for treatment or flexible schedule to get that treatment.
And Ashley, just to respond as well, you mentioned and I know we're not going to be able to get so far into this because our focus on this panel is the workplace, but you said that you encounter hurdles to accessing public benefit, public accommodation, public services as
Yeah.
well. And just can you reiterate those, because I want them to be clear to the audience, even though we won't have the chance as much later on in the program to explore them.
Okay, well, it's related to employment anyways. You know, if you have a drug felony, there's different programs that you cannot qualify for. You cannot get HUD housing. So if you're looking for employment or looking to, progress in life and make changes, housing does matter. If you are in a safer housing, you have a greater level of success in your recovery. However, we say you have a drug felony, so you don't deserve to have HUD housing or something of that related. SNAP benefits, you cannot have those because you have a drug felony. So we're decreasing the support when these people are at the point of saying, I want to make change. And that was kind of my point of that. So when you start trying to make change without any of the support, it's just very difficult to get up out of that hole. We want these people to return to employment, and sometimes that, getting an education can get you back to employment. Being able to have childcare services while you seek employment, that's very valuable as well. Think of the single mother with 3 children who has a drug felony. Now it's going to be very difficult for her to get a college education. It's going to be difficult for her to get employment that's outside of, fast food. Even some fast food restaurants will not hire her. And then we say she can't have this and she can't have that. So what is she to do?
Can I ask you just also to elaborate briefly on the point you made about probation not referring people for treatment with the intention, I guess, of preventing the person in probation from potentially losing their job. Is that?
Yeah,
So can
exactly.
you explain, how do you learn about those situations? Have you received referrals from someone who stayed on probation, tried to hold on to their job but failed, and later was referred to your program, or how do you interact with those folks?
So, if someone is placed on probation and they fail the terms of their probation, which would be to maintain, clean drug screens, then they could face further, legal consequences of that. Their probation may be revoked, or they may be, further referred for services of treatment. And when you enter treatment, then you're not going to be showing up for your job. And, you guys heard, I'm sure, at lunch, the counties that I serve, employment, is kind of extremely limited. So if you're not showing up for work, there's 100 men behind you that will show up for work. So how can you argue, keep this man employed, when there's 100 deep looking for a job as well?
It's a challenge. I may begin by pivoting from the general discussion of the experience of our subject matter experts here. I want to thank them all three again, especially Ms. Bledsoe. I know traveled probably the greatest distance. So thank you for coming and sharing your knowledge. And this is being videotaped, so it will be of benefit to others around the state and in the future. But I'd like to briefly introduce why we have focused on the workplace. Ms. Bledsoe described the impediments to accessing public services that are encountered by drug addicts and recovering drug addicts, and the protections that recovering addicts receive for accessing public accommodations are important protections, and we don't mean to neglect to discuss those protections under the ADA, but we have this paper in our exercise in advancing this discussion focuses on the workplace for two principal reasons. The workplace is a significant source of opioids in our communities, and the workplace is also an asset for recovery. And I want to, the paper sets out a little bit more about why those two things are true. The workplace has contributed to the oversupply of opioids that fueled this present epidemic, notably through the prolonged prescription of opioids in the workers' compensation system. It's known as opioid maintenance analgesia, and our paper explores a little bit more about the appropriate, generally speaking, what is medically regarded as an appropriately brief window for the use of opioid maintenance analgesia, and we emphasize that despite the relatively narrow window in which opioids are typically helpful for the alleviation of pain and successful recovery from orthopedic injury, nonetheless, opioids constitute over a third of the total medical expenditure on workers' compensation claims that are longer than 3 years in length. So our paper refers to national numbers, and I'm referring to national numbers right now, but on a national basis, opioids comprise over a third of the total medical expenditure on workers' compensation claims that are lengthier than 3 years. So the workers' compensation system appears to be delivering opioids to injured workers over a much longer period of time than you might think that opioids would typically be medically beneficial for the short-term maintenance of severe pain. Prescriptions prescribed opioids continue to be a persistent source of addiction-related deaths in West Virginia. So this problem of prescription opioids causing addiction and death in our state clearly continues to persist and to grow. In the paper sets forth the rate of increase in opioid deaths from new classes of drugs continues to increase. The OxyContin, the sort of the earlier generation of opioids from the 1990s and early 2000s has been eclipsed by a rapidly expanding overdose incidence among other classes of opioid drugs, including specifically gabapentin, and the numbers on the increased rate of overdose deaths from gabapentin, which is another pain management medicine commonly prescribed in the state of West Virginia, are really staggering. The incidence of death has increased by several thousand% from gabapentin overdoses in the last few years in West Virginia. So the workplace and the workers, the workers' compensation system is a significant source of opioids. Opioids account for, and again, I'm referring to national numbers which date from the year of 2012, but the opioids account for an average of 25%, fully a quarter of the overall expenditure, or pharmaceutical expenditure by workers' compensation payors. And opioids constitute 35% or more of that expenditure for claims that are over 3 years in length. So I wish to describe that the significance of the contribution of the workers' compensation system in the workplace to the availability of opioids in the community. That is, workers' compensation insurance provides the primary payer source for getting these opioids out into the communities in many cases. Additionally, it bears noting that the public transparency regarding workplace prescribing practices or in workers' compensation claims has diminished in West Virginia specifically since 2004 due to the privatization of our workers' compensation system in West Virginia, which when it was privatized beginning in 2004, 2005, the legislative rules for the privatized system allowed private insurance carriers and self-insured employers to exercise authority over the medical determination regarding how long an injured worker should be on opioids. So whereas in the Medicaid system and other healthcare delivery systems, we have public reporting, transparency about opioid prescription rates. Generally speaking, in a privatized workers' compensation system such as we have in West Virginia now, the medical decision about how long to extend the provision of opioids to an injured worker is a private decision that is very hard to analyze on a systemic basis because these are private data sets. And I have been able to find some public studies conducted by trade associations in the workers' compensation business that summarize the incidence rate of opioid prescriptions as I've described. But we suffer from a lack of public transparency about the incidence of extended opioid treatment in our private workers' compensation system in West Virginia. So secondly, in addition to being a significant source of opioids, the workplace is an asset for recovery and was noted in the introduction. Unaffordability and concerns of workplace repercussions are among the most common reasons reported by untreated addicts as the reasons that they don't receive treatment. I would like to turn it over to Professor Lofaso to set out the legal framework that we're looking at for reacting to this problem in the workplace.
Thank you, and I'd just like to thank the panelists for their presentations. I think what we tried to do is set out that there is a problem, and not just that, oh yeah, there's a problem, but that the problem is actually extremely complex. And the complexity of the problem deals with the fact that we have what I like to call the broken worker. But what I think many people view as the undeserving poor. And that's a term that came into usage in the English language in around 1600 with the Elizabethan Poor Act laws. And this idea, and it stems in a certain brand of Christianity. Obviously not all Christians believe this, but that somehow if you are able-bodied and are not working, that you are undeserving of charity, undeserving of helping. And this is how many of the addicts, alcoholics are perceived, as opposed to a broken worker. We heard today with Dr. Deskins that the labor participation rate is 10 points below average and the worst in the country, and that the only way that we will see economic recovery in the state is to get that up. Well, we cannot get that up if these broken workers stay out of jobs, which means it's in our interest, regardless of whether we believe they are undeserving of our charity. It is actually in our interest to help these people get back into the workplace and be productive members of our society. So what we want to do is the law is there not to regulate just because we feel like regulating, but the law is there to do things when there's a problem, and we have now at least begun to think about unravel the complexity of this problem. So what we've done is we start with this title, which is Working for Recovery, How Civil Rights Laws Can Facilitate Successful Rehabilitation for Alcoholics and Drug Addicts. And in many ways, this is a very misleading title, because what has happened is, in some ways, this came about so quickly that the law, which is inherently conservative, what I mean by conservative, it doesn't like to change, it has not had time to react to this crisis. So therefore, the only thing we really have is the ADA and then state human rights laws. So that means that in giving this legal framework, what we're going to see is, in addition to show you what maybe we can do right now with what we have, that there are many gaps in the laws, and that's why we really need our medical professionals here to explain to us what's going on. Lawyers are not experts in these fields. We are experts in the law, and we solve problems. It's our job to listen to what these experts say, to understand the problem, to study the problem, and then to propose solutions that we put into the democratic process, and we decide what our values are and what our priorities are and what we're going to spend our money on. So we have a federalist system that has state and federal, that we have both overlapping systems of regulation. And what we have here is the Americans with Disabilities Act, which is our federal statute. And then we have the West Virginia Human Rights Act here in West Virginia. And in pretty much every state, there's another Human Rights Act. And they are like what I call little ADAs, little Title VIIs. And they protect, usually more broadly, they protect the civil rights of, in the case of Title VII, of workers in the workplace. So whenever you create a right, so when a legislature creates a right, whether it's at the state or the federal level, they create a correlative duty. That means someone has to hold a duty that they owe to the rights holder. So the rights holder here would be the worker, what some people think of as the undeserving worker, what I'm calling the broken worker. And in this case, it's the employer. Now, we spend a little bit of time in the paper explaining why we think that the employer may be held to have some duties, but that might be also unfair, right? Because, and Sam just talked about it, because it was through the workplace that this problem happened, through the workers' compensation system. But who are the duty holders? They have to be the taxpayers through the government, or employers, privately insured. So we're just thinking right now, to the extent that an employer is a duty holder, what can an employer do? Okay? So that's what all those were about. We have 3 categories of workers who can receive protection under the ADA and the West Virginia Human Rights Act in relation to an addiction. And the first is that the worker has an addiction that currently places a substantial limitation on one or more of the worker's major life activities. I'll explain that in a second. I'm just going to go through the 3. The second one is the worker has a record of being substantially limited in a major life activity. That was in the past due to the alcoholism or the drug addiction. And the third one is that the worker is regarded by the employer as being an alcoholic or a drug addict. So we have the actual addiction, the record of an addiction, and also being regarded as an addict or an alcoholic. So what we have here is just looking at, I color-coded this so that's easy to follow. We're looking at the first type of establishing protected status, which is the addict. And as we see, the addict must, the worker must have an addiction that currently places a substantial limitation on one or more of the worker's major life activities. Well, major life activities is very broadly defined as including conditions such as concentrating, thinking, communicating, interacting with others, or some sort of brain function. And we know that people who are addicts and alcoholics will typically be impaired. Well, what's a substantial, in their brain function? What's a substantial limitation? Again, it's meant to have expansive coverage that usually will not require some sort of scientific, medical, or statistical analysis. So it's pretty, if you're an alcoholic or a drug addict, it's not going to be too difficult to at least establish protected status under this prong. Record of is just that in the past you were an addict, essentially. It's the same thing, all right, so you have a record of. So this could be someone who's a recovering addict. As you probably know, no one's ever cured of addiction. I think there are some places that say they cure it, but the medical consensus is that this is a chronic illness that is never cured. And so people who were an addict are always in the recovery stage. And then regarded as just means that the employer regards the worker as someone who's substantially limited in a major life activity, okay? And that would be because of their alcoholism or drug addiction. So that's just the basics, and so you can tell who those people are. The other thing is that we have 3 different causes of action, the first being the failure to accommodate, which I think is most interesting for this point. The other 2 are disparate treatment and disparate impact, but the failure to accommodate I think is the most interesting because it's really the accommodation process that I think has a lot of meat in it, and that we were really talking about, and that what Sam was teasing out of our panelists. So in the failure to accommodate cause of action, this means that the employer didn't accommodate when you asked for one, is that the employer, what the law does is places a duty. Remember we talked about duties, if you have a right, you have a duty. So, all right, I'm disabled. So now, what does that mean? Well, I'm disabled, but I can do my job if you accommodate me. So for example, what if I'm blind, but I could be the best lawyer ever, but I need to have things put in Braille. Well, as long as that's not financially burdensome to the employer, it might have some financial burden, but as long as it's not going to bankrupt the employer or something like that, then they have to accommodate me. They can't not give me the job or fire me because I'm blind. Okay? So here, let's say the employer has this duty to reasonably accommodate addicts, so the addict might need a part-time, we heard this, it was exactly what we heard earlier. They might need a part-time schedule to support in or outpatient behavioral therapy. They might need flex time or intermittent leave to attend random drug screenings, rehab sessions, Alcoholics Anonymous, Narcotics Anonymous meetings, healthcare appointments, and medically assisted treatment. I'm hoping that the panelists will talk about that it's only through this type of treatment that addicts will stay clean. And so we can actually get more production from them if we actually accommodate. It's actually cheaper in the long run from the employer, for society, to keep them and to give them these accommodations. This is a very fact-intensive inquiry. Forgive me, I'm a lawyer. I have to explain these things like that. So most of you probably don't care that it's a fact-intensive inquiry. To establish this claim for the failure to accommodate, the employee, so the addict bears the burden of showing that he or she is a qualified person with an addiction. So usually they're already in the workplace and they need an accommodation, so they are obviously qualified, right? Because they are doing their job already. That's usually pretty easy to show. The employer knew about the employee's addiction. The employee required an accommodation to perform the job's essential functions. A reasonable accommodation existed that would have met the employee's needs. The employee knew or should have known the employee's needs of the accommodation, and the employer failed to provide the accommodation that would have enabled the employee to remain in the position. Now, we don't require employers, as I said, to go bankrupt. That's, but so there is going to be a financial test to that. But usually this is, yes, you can take an hour off on these days to go to these meetings, things like that, okay, and other things, and that's what we want to hear from the panelists. disparate treatment is basically intentional discrimination, and that's when you're discriminated against because of your addiction. Here again, the employee bears the primary burden of showing that the employee has a disability, is qualified for the job, and that the employer discharged or took what we call an adverse employment action. That means it could be a discharge, a failure to promote, it could be a more onerous job duties, but something adverse, we all know what that would be, right? So the employer discharged the employee, at least in part because of his or her disability, addiction, actual or perceived. And then disparate impact is really, it's usually, but not necessarily unintentional discrimination, but it's where the employer has a policy that has a disproportionate impact on addicts or the disabled person. So here, to establish a claim, the employee must show that something called the prima facie case, which I'm going to just show you in a second. Then if the employee is successful in showing this prima facie case, the burden shifts to the employer to prove that the practice is job-related and consistent with business necessity. And the employee can then rebut this defense. Let me put that in a better context for you. So the prima facie case is the employee must show that the employer has a particular employment policy or practice that has a disparate impact on addicts. That the employer must, now once they show that, if the employer proves that the practice or policy is job-related and consistent with business necessity, okay, well that's good. So for example, drug testing has a disparate impact on addicts, right? But if you are a train conductor, as we've seen recently, you might want to have train conductors to be randomly tested, okay? So that's not, just because it has a disparate impact doesn't mean that it's a discrimination that's unlawful. So the employee can then rebut the employer's defense by showing that a less burdensome alternative practice existed, which the employer refused to adopt. And so what we're trying to do is keep as many people in the workplace, because we want people who are disabled, even those who some of society perceives as undeserving, we want those productive members in society. Personally, I think it's a human rights issue in addition to that, but I think a more persuasive argument for some people is this economic argument. And then this is just legalese that you can use statistical evidence to prove this. I'm sure you're not that interested in that. So I just want to thank my panelists, and especially, and also in addition to my panelists, Ken Price and the West Virginia Law Review, and all the invisible workers that made today possible. It's really, I do appreciate, Zach has worked really hard on the paper, and Rebecca, I don't know if Rebecca's here anymore, but she was. I really appreciate it. So thank you. I'm going to turn it over to Sam now to do the hard part of the law.
Well, so the hard part of the law is this question of determining when somebody loses their protection under the ADA or the West Virginia Human Rights Act. And our paper goes into how some related laws also apply. There's a relatively new drug testing law in West Virginia, one which is specific to the coal mining industry and one which is economy-wide, and the paper explores a little bit more detailed level of the interplay between an addicted worker's protected status under these human rights laws and their drug testing obligations under the pertinent drug testing laws. But as Ms. Batiste mentioned in her remarks, the disabled drug-addicted worker loses their protection as a qualified individual with a disability under the federal Americans with Disabilities Act if they are currently engaged in the illegal use of drugs. That it means under the law that the person is not regarded as from a legal standpoint as a disabled person for purposes of the ADA. They may be impaired, but they're not legally disabled, and the rights and the duties don't arise for that person. Under the ADA, if they are currently engaged in the illegal use of drugs. And the method for determining, the legal tests for determining whether someone is currently engaged in that type of illegal use of drugs vary to some degree around the country. And we explore it in the paper, but in general, if I am discovered by my employer to have failed a drug test, and I am discharged on the spot, the inquiry is pretty simple. I've been currently engaged in illegal use of drugs at the time that I was discharged. If I'm subject to some discipline and I'm accommodated, as I probably am, at least under state law, I may be entitled to an accommodation. If there's a delay between the time that my employer learns that I'm currently engaged in the illegal use of drugs and the time that I'm ultimately discharged, it may be that the delay is of a sufficient period that I regain my protection from discharge or adverse action based on my disability under the ADA and under state law. So although the federal ADA provides a bright line test for removing the protection for drug addicts who are currently engaging in the illegal use of drugs, it is also the case that a separate and independent body of protection for recovering addicts and for drug addicts, as Professor Lofaso mentioned, exists under the West Virginia Human Rights Act. And the West Virginia Human Rights Act does also remove the protection for disabled, for addiction-related disability if a worker is currently engaged in the illegal use of drugs. But the West Virginia Human Rights Act, unlike the federal Americans with Disabilities Act, only removes that protection when the current use of addiction or the current use of or addiction to alcohol or drugs prevents a person from performing the duties of their job in question, or when that current use would constitute a direct threat to the safety or the property of others. So there's a little bit of a higher standard for being disqualified from protection under the West Virginia law than there is under the federal law. And I think that's really important because that's our state human rights law saying, even if you are currently using drugs illegally, if it's
or legally,
but even if the federal law, so the value system under the federal law would disqualify you from protection because you're currently engaged in the illegal use of drugs, under our West Virginia Human Rights Act, we are also going to make a second inquiry and ask, is there a way that we can accommodate you? Is there a way that we can ensure that your current use of illegal drugs doesn't pose a direct threat to the health or safety or property of your coworkers or your employer? And if it would pose a direct threat, then you're going to lose your protection. But if perhaps, though currently engaging in illegal drug use, it's not of such a substantial measure, or your job duties aren't of such a nature that the illegal drug use is posing a direct threat or preventing you from doing your job, then you may still have the rights for accommodation and the right to be free from discrimination because of your disability. And I think that's an important expression of our value system in our West Virginia human rights law, and it's an important signal to workers and to employers that you have to make a second inquiry even though somebody may be currently engaged in the illegal use of drugs, and it's how significant is that drug usage and what's the nature of this person's work. And so we want to emphasize to workers and employers in West Virginia that you don't just write somebody off, even if you think they're currently engaging in the illegal use of drugs. That person still has some protections. It means you as the employer still have to ask a little bit more and figure out is it possible to accommodate this person? And what's the real threat of their drug use? If they're if they're a surgeon or they're probably proposing a direct threat to someone else's health or property if they arrive at work under the influence of drugs. So the current use rule varies under the state and federal law, and generally speaking, the federal law also sets out a helpful system, which essentially for public purposes and purposes of general discussion, there's a concept in the federal law, and Ms. Batiste, you might want to say more about this, but the federal ADA provides what they call a safe harbor provision for individuals who have been or are currently in drug rehabilitation programs. And from a legal standpoint, what the safe harbor concept means is that you don't have to go through a lot of medical rigmarole in proving whether you're disabled or not. If you're in drug rehabilitation, the federal ADA really clarifies to us that you're a qualified individual with a disability. And now, if you're currently engaged in the illegal use of drugs, you may still lose your protection. But the safe harbor concept is meant to clarify that our disability laws are there to protect people who are in rehabilitation. It really shouldn't require the same kind of medical inquiry that you might have to have in another type of disability case as far as how substantial is the limitation on your work activity and so forth. That's some additional perspective on when it is that a worker may lose protection from the ADA and the West Virginia Human Rights Act. I want to probably turn back to the panelists here because we've got about 10 to 15 minutes left, and I'd like also very briefly to observe the fact that we don't have we haven't discussed, and I don't want to assume one way or the other, but we're not presenting the perspective of an individual with an addiction on this panel in the first person, and I think that's a shortcoming of the panel. But I hope that the breadth of perspective that we're offering here by all these professionals may serve to compensate for that shortcoming on the panel. And so turning back to the panel, I'd like to pose in our paper, we explore a number of cases, federal and state cases that address and seek to resolve the dispute between the employer's interests and the worker's interests. One case in particular we explore in some detail, and it's a case of Rogers against Laymen, which is a Fourth Circuit federal appellate court case that sets forth a 5-step test or a 5-step framework that represents a sort of a model framework for providing reasonable accommodations to alcoholics and also, I believe, to drug addicts who aren't disqualified from workplace protections. That is, drug addicts whose current drug usage isn't disqualifying them by way of being a direct threat, as I described under West Virginia law. I think it's quite a widely applicable framework for providing accommodations. And the 5-part framework, which I'll ask maybe for you to respond to on the panel, is that the employer must, when they become aware that an employee has an addiction issue or a drug use issue, the employer has a duty to inform the employee, the worker, of available counseling services, part 1. Part 2, if unsatisfactory job performance continues after the notice to the worker of available counseling, the employer must clearly and unequivocally warn the worker that unsatisfactory job performance caused by addiction will result in discipline. This is sometimes known as a firm choice or a last chance agreement. So first, notice. Second, last chance agreement or firm choice. Third, the employer must allow the individual to participate initially in outpatient treatment, and that's significant. The opportunity to have outpatient treatment must be distinctly made available to the worker. Fourth, if the outpatient treatment doesn't succeed, or if in the judgment of the employer and the care providers that outpatient treatment is inappropriate, then the employer and employee have to agree for the employee to participate, have to enable the employee to participate in an inpatient treatment program. And fifth, if after notice, firm choice agreement, outpatient treatment and inpatient treatment, the problems persist, then the decision by the employer to discharge that employee is presumptively reasonable and non-discriminatory. And that's a 5-part test. And after, in light of the issues that you've raised here in our discussion about the legal universe, I wonder if you have reactions to problems, advantages, concerns about inviting employers to adhere to that 5-part process for reacting and supporting people struggling with recovery.
I know in our work at Jan, we talk to employers who are dealing with employees with addictions, and sometimes they do want to keep them in the work environment, but they're afraid they won't get treatment, they won't adhere to their conduct requirements. And generally under the ADA, employers are not allowed to dictate treatment or tell you to get this medication or tell you to do this. This is an exception when the person would otherwise be disciplined or terminated. The employer is free to offer a last chance agreement and say, you do this, this, and this, and we won't fire you or we won't discipline you. And I find that a lot of employers are very interested in doing that. If they feel like it's a way we can give this person a chance. Maybe it's a good employee, maybe they just want to take that route, but at the same time protect themselves because of a violation of that contract and the person's out of there. So in my experience, I think this is a really good approach that I think a lot of employers would adopt. Gives the person a chance, hey, last chance, you can do this or you lose your job. And for some people who maybe got caught in a drug test, it wakes them up sometimes, sometimes not. For people that want treatment, it's just a good way that they get that opportunity to do that.
I also, think that it's a very fair approach. It does give them an opportunity and chance. My question is insurance coverage. Who's paying for treatment? And where will they access it at? If they're a rural employer, where are they going to get this treatment at? And then you're also going to be increasing the people you're sending into treatment. So who's going to be providing for them? One of the discussions that I mentioned earlier is that there is a cap on how many people who can be in group therapy. I personally think that's a wonderful thing. I don't think we need to overcrowd our group therapy as we've overcrowded our schools. But with that said, it does limit providers being able to make contact with people of need. But you don't have more providers coming forward either, and there's a lot of reasons for that as well. So insurance coverage, and then we have discussions about Medicare and Medicaid paying for substance abuse treatment, and that's once again another issue. You take that away, then you're really up a creek. And then people within the state of West Virginia who actually provide substance abuse treatment don't always allow private insurance. Like they don't accept private insurance. So then you have people going out of state to seek treatment. And that's costly for the person, costly for the insurance agency, and that also increases the amount of time that they're away from their employer. If you're all the way down in Georgia getting treatment, you're sure as heck not showing up for work on Friday. So I think that there's some practical issues that also need to be considered.
I'd love for the panel to react to that question about insurance. I think this framework is intended to try to hold on to the employer-provided insurance as a payor source. And part of the value of this framework is it's attempting to shake additional resources out of the employer community to support in lieu of putting it on Medicaid and Medicare. But of course, not everybody's employer carries medical insurance, and there are a lot of issues. So I'd love for the panel to react to your point on that. But first I'd like to hear from Bob.
Yeah, I got too many things to say. One thing I want to say is, and I want to say this calmly because I don't want this to be hostile, but I believe this. If we lose Medicaid coverage, or if it's reduced in this state, then the ability to treat drug addicts successfully is going to go out the window. If you think it's bad now, wait until that happens. So that's just a fact, by the way. So, and therefore the issue of insurance is incredibly important. Somebody's got to pay the bill. It also overlaps with a couple other issues, which which I have in terms of, even using the ADA, who's gonna guide these people? I keep thinking about this was a lawyer's kind of a setting. What can be done or what is done that might facilitate, like legal aid or something, because people don't have money. And we know that for other issues, that people, when they don't have funds, sometimes there's services that can be set up. But I think I may be wrong about this, but I wonder if there's not a gap in that and connecting these people, because when we see folks, they don't seem to have anybody they can go to. And again, if you recommend just a straight out lawyer, he's got $5,000 for a retainer fee.
Yeah.
And so there's a lot of that on a practical level, I'm just being honest with you all, that comes up. The 5-step program process, I think if it's done consistently, is an excellent thing. It's part of what policies and procedures ought to contain. The element that maybe is not missing but ought to be added is have an employee assistance program. About step 1, if not between step 1 and 2, they should be referred. It could be mandatorily if it's set up that way, so that these persons are adequately evaluated to see what issues are impacting their lives. And then they can get help then. But therefore, there needs to be that set of steps in place. But if I may real quickly, I apologize for this, but a couple comments.
We are getting, they're slitting our throats on us back there, so, but if you can just wrap up, yeah, maybe.
Well.
And we hope this is an ongoing conversation.
I understand.
Yeah.
There's a few things I wanted to say, but I don't know if there's enough time regarding, the workers' compensation, the overuse of opiates. Very quickly, classic story in our treatment program. Any number of years ago, we treated a man who was a superintendent of a mine, current. And he had had an accident 10 years before, seriously injured his back, went to the hospital, came out, and as a result was on opiates, because that's what you do when you have a back injury. He was on these for 10 years. And the irony of this is that he also had a private pilot's license. And the FDA frowns upon people flying planes on drugs. So he didn't fly his plane for 10 years because he thought he couldn't, because he thought that he was in so much pain. When he finally went to our inpatient unit and got detox and came to in the program I have, he was virtually pain-free. And the reason why is because if you give people opiates long enough, it will exacerbate their pain.
Yeah.
It will make it worse. And so all these persons that come, many have needs, but often it's not the needs that they think they need. And until people have an opportunity to get that evaluated truthfully, and people will fight you. They don't want you to take their
Okay,
their drug
we're
course.
really getting axed here. I want to thank everyone very much for participating.
I want to say,
You guys have some great
Thank you,
points.
guys.